Welcome back, ladies and gentlemen, to the Layman's Law School, where three Southern gentlemen lawyers talk about the legal issues of the day, hopefully in layman's terms that you can actually understand, and you learn a little something about the law, and you enjoy listening to some country folk
smooth Southern drawl.
That have a little
Hopefully you enjoy it. That's for sure.
Exactly, a little bit of education in the area. And today we're going to be talking about two things. First, we're going to talk about the Disney case. In which there's an arbitration clause that Disney's trying to enforce to keep them out of Florida courts, and then I'm gonna do a little bit of a update on the Karen Reid trial. But before we get started, Reid, do you want to subject me to the usual torture?
Before we get started, I've got a little gift for Chace.
Nothing for me.
Chace's birthday weekend. So
Right.
I know that he would probably enjoy some Tap 33 Brewery Good Googly Moogly Juicy India Pale Ale as opposed to the Bud Light for today.
Oh my goodness. Let's see. Reid,
that's fine.
I'll drink Bud Light with you,
Right.
Reid, but I want Chace to have all of these.
I'll let this slide just because it's his birthday.
I mean, he's finally 40 years old. So, it's a big year.
Reid, this is how you have a friend, okay? Just so you know. Okay.
Listen,
this is what it looks like.
Episodes ago, I dug up your artifacts of I can't remember the name of it. Do you remember who drunk it? Or
the monk beer?
The monk beer.
Yeah.
Cheers. Happy birthday, Chace.
Brother.
Thank you, sir.
Good googly moogly.
Yes.
See how that one is.
It's no Bud Light.
Oh, that's delicious.
That's what I said. I just said it's no Bud Light.
But I will say it has a hint
I can smell the hops from here.
of cannabis. So, like I said, we're going to be talking today a little bit about the Disney case. And for those of you who don't know, it's been in the news lately. There was a doctor, a 42-year-old woman, Miss Ting Swan, who was eating at the Raglan Irish pub in what is known as Disney Springs. It's basically a commercial
like a
shopping,
little city within Disney.
Right, a shopping district. It's actually outside of Disney, but it's owned by Disney. It's a shopping center owned by them. And the husband is actually suing her for wrongful death because when they went to visit there, they informed them that she had some very severe allergies to dairy and also to nuts. And this is a woman that walks around with an EpiPen everywhere she goes. She was reassured. She ordered all vegetarian items from the menu. Was very careful about what she ordered, and she was reassured by the wait staff that foods are kept separated from because it can be important. If you have a shellfish allergy and you're eating a steak, let's just say, that was cooked on the same grill as shrimp were cooked on, you can still have a anaphylactic shock, and that's what occurred here in this case. Within an hour of her consuming these vegetarian items, she went into anaphylactic shock, and despite her immediately administering the EpiPen, realizing something had gone awry, she passed away. And her husband has brought a wrongful death lawsuit under the Florida wrongful death statute, seeking $50,000 in damages plus additional damages.
And that was very interesting to me. I've never seen, at least here in Georgia, where we practice, a wrongful death case for $50,000.
Right, and now, I did not have time today to go through in detail the Florida statute, but what that sounds like to me is there is some specific part of the statute that limits some recovery, and in any wrongful death case, you're gonna have two claims. There's gonna be the estate claim, and that is the claim that the person has, and their estate that always has to be brought by the representative of the estate, and you're going to have the actual wrongful death claim, and that's the claim that the family has for the loss of the person that they were connected to.
Sure.
And so,
and to be fair, wrongful death recovery can be extremely different state to state. Yep. South Carolina and Georgia are almost polar opposites.
Yeah.
But like you said, I mean, Georgia, that's what we have, but it can be. There's different types of recovery. It kind of works out the same, but you have to get there in a different avenue. Is the easiest way to explain it.
Yeah, but what it sounds like to me with that $50,000 is there may be some sort of limitation on what the estate can actually claim versus what the wrongful death can actually claim.
And I also think there is there has to be an amount that is high enough to have that, and so that 50,000 is a placeholder.
That's right.
That's all it is. Yeah. It's just to get the thing moving.
That's right.
Well, I also thought about it. I just not knowing anything about why it would be 50.
Sure.
Is it some type of an attempt to keep it in a Florida state court as opposed to there's an amount in controversy requirement when you have diversity of parties, which means parties from other states. If this doctor was from another state and Disney is from another state, and the amount in controversy is over $75,000. The federal law provides for them the allowance to remove it to federal court, which can be a lot more intensive litigation process, especially for the plaintiff's, attorney.
Yeah, it's federal.
May not be used to
me, in my opinion, it is a lot more difficult in like premise liability, and this would kind of go under that category. Than state law, which obviously I disagree with, but the federal side on any kind of wrongful death on premise is much more. There's just more things that are required, and it's more decided by a single entity than a jury on most issues. In state court and superior court, you're getting decided by a jury on a lot of things, and this is kind of federal is a little bit more. Here's the rules and whatever it is. You don't make an argument. It's just what it is.
Yeah, and
Shawn, same thing as when you did criminal work. Same thing in federal and criminal, I guess.
Absolutely.
So, now discussing that $50,000, you said that might be an attempt to keep it in state court, and part of the reason why that might happen is typically the courts are set up within the county in which it occurs in any given state. And so that might be a county that is actually very, very favorable to plaintiffs.
Certainly.
And so the law firm that's bringing the lawsuit may have chosen that county and put that $50,000. I don't think that's going to, keep it out of federal court, because the fact that this person was a doctor, what she's earning per year in New York, right? They are definitely
a month of her wages exceeds the 50.
Exactly. It was you have to try. Answer's always no unless you ask, and so they try to keep it in state court. They anticipated it being moved to federal because there is some diversity. In other words, there's a representative that is, or these are defendants that are in Florida, and then the plaintiff is from New York, and that goes back to people used to. At the beginning, when all those laws were being written, people used to just not trust, people from another state automatically.
Sure.
Like people identified
before it was the world got smaller with the internet and everything else. I'm from Thomson, and we didn't trust people from Augusta, and now I go and the high school kids know each other and all that stuff. But that's a legitimate concern
back then.
And like I said, this is kind of one of those things that people look at and go, lawyers are so stupid. Why would you do $50,000? It's purely strategy. We don't know what the strategy is. And it might, like you said, it could be a court. It could be what entity you can bring in. But I assure you that number is not made up, it is for a specific purpose.
Right. So, but here's the main issue that I guess has got everybody riled up. All right, is that the Disney lawyers have tried to use the widower husbands subscription to Disney Plus, the terms and conditions in that subscription, that every single one of us scroll all the way to the bottom, or don't even scroll, and just accept the terms on every app that we download, on every subscription that we actually sign up for, and they're trying to hold him to the terms of that particular contract that he signed with them. In addition to that, he's also got the additional terms and conditions of the fact of the purchase of the tickets to Epcot Center, which they actually never made it to, but they did purchase those tickets, and by purchasing those tickets, you are agreeing to the terms and conditions, and in there is a clause to arbitrate. Can y'all explain to the viewers what arbitration is and kind of how it affects consumers versus corporations?
Sure. Arbitration is when, we deal with it more in a mediation standpoint, and a mediation is where we have a neutral party who hears both sides of the case and tries to get us to resolve the case. Goes to each side, tells them their strengths and weaknesses, tries to convince one side to pay more money, tries to convince one side to pay less money. In arbitration, it is very, very similar, but this is a neutral or supposedly neutral individual who is hearing the case in its entirety and making the decision with very, without the stresses and a lot of the discovery issues that would be involved in a litigation case in courts. If you have to go to a arbitrator or binding arbitration, you're agreeing to waive essentially your right to a trial,
right?
And you're agreeing to let some arbitrator. Then, in my experience with these arbitration clauses, often the arbitration clause, picks exactly who the arbitrator is, and you agree to that in the terms and conditions. And for some reason, these arbitrators that are used, by these companies, at least the research suggests that they are overwhelmingly less inclined to grant injured people relief than juries would be.
And one thing I want to throw out there with the outrage over this is the country's doing, right?
Sure.
And what I mean by that is you hear all the time people, the courts are just, you can't trust them, the judges you can't trust, and the juries you can't trust, and they want arbitration. Well, can you trust an arbitrator? I mean, if you can't trust a judge and all this, there's no process after arbitration. Like in a court system, you have checks and balances. And there's always a big push for it. And there's some things I think should be arbitrated. But one of the biggest arguments is, and this was when medical malpractice and all that stuff it was pushing for arbitration, is that it's such a complicated issue that you're putting the arbitrator or the arbitration panel that they're experts in that field.
Sure.
Now, in this case, I don't know how you can be an expert in food allergies or death of food allergies. I mean, I guess you can, but do you really have to be an expert to understand if I eat something that I'm allergic to, it could kill me? And if you serve somebody something that they're allergic to, can kill you?
Right.
That with the knowledge that they had this allergy.
Right. So, arbitration is very effective and good in some areas. One of the things being international disputes, which law applies, all that stuff. So, you can kind of come in the middle. This is not a complicated issue. And these carte blanche arbitration agreements, a lot of them will be struck down because this isn't under the scope of what that is really trying to get at. And that's kind of that arbitration clause is more to deal with recording things and using them to make money off of. Not if you go to the park and die.
Yeah, and
it's just not the same.
Yeah,
it's just,
and it's a part of being able to economically offer volume subscriptions, where if there are issues with that subscription, the idea that every single person that signs up for Disney Plus could then have a jury trial to
on a dollar dispute,
on a dispute about them raising the price or some issue that they didn't get service for a day because there was an outage in their service or something like that, then they're going to actually have a jury trial over that. I mean, I think that is the reason why the courts have said, okay, this kind of thing can be valid. And
I'm glad you brought that up, because most of these contracts that have this particular language also, you are waiving your right to participate in a class action lawsuit for that same type reason.
And so, I mean, you need to understand that when you're doing these are called click wrap agreements, and that's just basically they're wrapping up all these terms in one single click. Right, it's a legal term that we've used.
And some of them, if you notice, and this is intentional, some of them make you scroll all the way to the bottom to be able to click the box, right?
Yeah,
and that is to
be able to indicate
to show that side says they had to have read it, even though they know you didn't read it.
Right.
It's
they scrolled all the way to the bottom.
All the way down. It's another feather in the cap kind of thing.
So, but this is a good example, and I want people to understand that it when people talk about lawyers and the way that they do, that they need to understand that originally, I want to say like back in the 90s, early 2000s even, the people that actually pushed for arbitration were credit card companies. Okay, and in the early
big guy. I mean.
well, in the early days of arbitration, it was very common for the ownership of these arbitration courts to be private. And I think it was in the early 2000s when they estimated the ownership of private arbitration courts. It was 95% owned by credit card companies.
Oh, imagine that.
Shocking, really.
Right. So if there's not a conflict of interest in that particular arrangement, then I don't know what is. But that was overturned by a lot of different decisions, and it was the bars of different states, the trial lawyers, the lawyers in that state.
Not the bars that serve alcohol.
No.
The legal bars.
Yeah.
Could be both.
The bar is the governing body for the lawyers of the state, and it was the collective push of the lawyers in each individual state to demand that something be done about that type of problem. It's just fine if you're going to agree to go to an arbitration. If you read it, you understand it, you know that that's a part of the agreement. But then to have these captive people that are actually deciding the case, that are paid by
your
one
own
side,
employees, essentially.
Exactly. That we recognize that it's manifest injustice. And in Florida, the Florida bar has worked with other international and like basically national organizations to come up with an arbitration system that doesn't have these types of captive kind of arbiters. These people, these are usually, I mean, like they'll have like a panel of, but every state is different. 3 judges, 9 judges, 6 judges that all hear this stuff. 1 judge sometimes that hear the evidence, but they just don't impanel a jury. And the example for why those things can be so beneficial to get cases wrapped up quick is YSL. The YSL trial in Georgia.
Yeah. Successful lawyers.
Young's slime life. I don't know. He's a rapper in Atlanta, Georgia, but that was a RICO case that had a lot of different defendants. Had 150 witnesses on the prosecution side, and all of the jurors.
Is.
That
thing's still going.
Yeah, that's true.
We'll be dead before that's over.
But they had 10 months of voir dire where they were questioning the jury pool, a pool of people, to determine whether they could be unbiased. That's before any witnesses heard or anything. And every single day, that cost the taxpayer money, and it costs each side money.
It's a balance, no doubt. But you talking about the credit card one thing that I remember from that is one of the key things to that is disparity in bargaining power.
Mm-hmm.
Sure.
And you almost, especially today.
What does disparity mean?
It means that you got more power
one
than
side's
me.
getting screwed and the other side's not.
There you go. That's what we got.
So you got you got the big guy and the little guy essentially.
Yeah.
And so when you're dealing with something that is, now Disney is a little bit different, but with credit cards, it's almost impossible to go through the world today without a credit card. You may say, no, that's not true. Well, your debit card is a credit card. Like you almost have to get a hotel, you have to have one. So if you have to have things, and you cannot find a place that doesn't have an arbitration clause, the court's going to look at that and go, well, that's just not fair, because you have to have this as a member of society, basically, to make it nowadays, and you don't have a choice. And so you're giving up, and this is used a lot, a constitutional right. A right to a jury trial is a constitutional right.
Absolutely.
And so there's some things people say are that aren't, but that is. And so when the courts look at that, when you're giving up a right, it's almost impossible to give up a right. And so they're going to rule on the side of the little guy when you're giving up a fundamental right, more times than not. Not always, but more times than not. And that was the credit card case was there was a lot of reasons why they overturned that and made it different, but the underlying theme of it was who's got the power and who's abusing the power. And then it's find a law to make it where we want it to be different.
Yeah. And this may turn out to be some sort of watershed case where like things are different after it, because this is a type of thing that, and this is the reason why you see it in the news. That's the reason why we're talking about it. Anytime you have a little man that's having the shit kicked out of him by a big corporation, people get motivated by that. They absolutely hate it. They do not like it, And, you know, part of the reason why we're talking about this is we actually do want pressure on this particular case. We want this to turn out in a way in which justice is actually done. And it's been our experience, you know, over the last 400 years that the best way to do that is a trial by jury of 12. And
absolutely, the 12, you know, reasonable people are going to be the people that decide whether or not your case is actually garbage and throw you out of court, or whether or not this big company did something wrong and they need to compensate the injured people because of it.
Yeah.
What I was surprised about is, you know, I get the whole thing of, you know, deep pockets, who people sue and everything, but this, from what I've seen, this is a business, a restaurant that is not owned by Disney, not operated by Disney. I think about it as in like if you went to a TGI Fridays in the Atlanta airport, and it was actually in there, sure, they're renting a space, and if it's not an actual facilities issue or a premises liability type thing that the Atlanta airport was responsible for maintaining, you know, this is food being served by an independent restaurant that just happens to lease property from Disney. Why is Disney a part of it, you know, anyway?
Go ahead. I was going to say that, you know, my speeches and spills earlier about arbitration, I still truly believe that. But in this case, Disney's not responsible. They're not. I mean, but I don't believe in the arbitration. I think the scope of the arbitration clause is way out of line.
Sure.
And if Disney did own this restaurant and they did serve the bad food, then, you know, I don't think the arbitration survives. But really, I think why they're filing it to go to arbitration is to make a legal ruling on we shouldn't even be in this case. And I agree with them.
Right. Well, here's the thing about filing these lawsuits is that, you know, the plaintiff in this case isn't able actually to demand any information from either of these companies that they're obligated to provide them.
Yep.
Right. And there are situations that occur all of the time in which a company like, say, Raglan is a shell. In all intents and purposes, that thing doesn't even exist. That Disney is actually controlling that they own it through 3 different subsidiaries that you can track it through, that they're sharing banking accounts, that all profits go to Disney, that the Disney determines when the employees show up, who gets hired, all of that stuff. And so if Disney is operating this place, right, and controlling it and determining when the employees show up and all of that, they're taking all the profits, right? And
then it really is Disney.
Then it really is Disney. But here's the thing is that the plaintiff's attorneys don't have the evidence that they would need to either rule that out and say, okay, yeah, Disney is not a part of this, or to say, you know what, they do need to be included. And so what has to happen and what law requires is for him to file, and if he believes that that might be the case, and anytime there's a deep pocket that is connected to the case, that kind of thing could occur, and in this case, Disney owns a lot of Florida, and has been the biggest lobbyist in Florida, the state of Florida, for I don't know how long, right? Which gives me some pause about all this arbitration stuff as well, because it's very easy to actually establish a relationship with one arbitration judge or 6 arbitration judges or 9 arbitration, or maybe just in the state of Florida, 100, right? Versus finding 12 strangers that are willing to keep their mouth shut and actually take money under the table, or take free lifetime passes to Disney World in order to help somebody out, right? That's the only thing that makes me really nervous is about how that all might play out. But that's why Disney is included, because they want to sort out and be able to demand the information to prove that they're not or they are controlling it.
Ask both of you. I mean, just it's a softball question, but we have to do it all the time, and people get real mad at us when we sue somebody. But we have to. You throw a big net.
Yes,
and it's that same reasoning. I mean, why do we do that? It's because we don't know the information. When you're filing a lawsuit,
and if you find out 2 years and a day later that this person or company was involved and you should have sued them, You can't.
You can't.
In most cases, you can't. It's a pain in the ass.
A statute of limitations can prevent you from bringing a claim in a lot of cases like that.
Well, I mean, we have case after case after case where we have to name 10 different entities. And then when it's all said and done, yes, somebody was at fault, but it's only one. And you have to let all those people out. But you can't let them out until you have the evidence. And the only way to have the evidence is to put them in the lawsuit.
Right.
That's it.
And so I think that's important to point out the fact that she died in October of 2023. So Florida has a 2-year statute of limitations for the wrongful death claims, which means they have a full year to add whatever other defendants that they feel like might need to be added, and that's part of the strategy. When it's real 100%. Clear that it's one party, it's one person that's responsible, one company that's involved, you can, wait till the second year. But the damages in this case are already established. She's passed. Her economic damages aren't going to change. The fact, the damages are it's all determined. What they're going to be fighting about is the amount of damages and who's actually responsible.
Which entity is responsible for overseeing the service of that food.
And so filing suit before the 2-year statute of limitations in a situation like this is good standard practice that plaintiff's firm is actually using.
Yep. And Chace, to further your point, it's a situation where let's say that you think that, what's the name of the
Ragland
Irish pub.
Irish pub. All right, so the Irish pub, you look it up, and you go Secretary of State, and you see it's the Irish pub, blah, blah, blah. You file against them, and then, the damages are already set. You got terrible damages, and then you go through it all, and then at the very end, the owner of the Irish pub in a deposition says, actually, we report to Disney, and actually, all our profits are Disney's. What do you do? I mean, you're done, right?
Yeah.
I mean, if you didn't bring them in, so you have to. And like I said, there's people out there right now that are mad at me for bringing them in stuff. But I'll let you out if you didn't do the wrong thing.
Exactly. and the thing is that when you sue 10 people or 10 companies, entities type things, the ones that aren't responsible are very, very helpful immediately.
Absolutely.
They're the ones sending you,
everything.
Here's a copy
I'm not even in this
Here's
thing.
a copy of the lease. Here's the section that shows that, they are totally responsible for this type thing.
100%.
You're like, thank you. Okay, well, we'll take that into consideration.
So, ultimately in this case, I'm not 100% sure how this is going to shake out and where they're going to actually come and fall down on it. The Supreme Court has made rulings in the past that enforces a lot of these arbitration clauses because people are deemed to have read the contracts in which they sign. And I think some of it will also turn on the facts that Reid was talking about related to Disney's actual involvement in this whole thing as to how they fall on it. Because if they're not involved at all, erring on the side of getting them out and making it easier on Disney is something that the courts are going to have the discretion to kind of to rule in their favor.
I love to throw predictions is that I don't think this arbitration clause holds water. I think that you can't sign up for something to watch TV and then somehow give away your right to sue by physically going to a different entity location.
Right.
It might be under the same roof company. They own the same thing. But watching a television and riding a ride are two different things.
And that's why
that I don't think that passes. But I also think that when it's all said and done, that it's going to be the owners of the pub and not Disney. But I don't think the arbitration is going to rule this case.
Yeah.
And that's what I think the same thing, that the Disney Plus arbitration agreement, I think is way out of line to cover that type of
that specific thing. Yes,
the actual waiver or whatever they signed or arbitration agreement when they bought the tickets to Epcot is a little bit closer.
Stronger, but you have to be there.
Exactly. And I just keep thinking about, if I bought a ticket to Epcot or Disneyland or wherever, and then a month later was in Cincinnati, Ohio. And a Disney employee in a Disney vehicle,
right? That's a great example.
Ran a red light and T-boned me, causing me super injuries.
Yeah.
Would they be able to just say, "Oh no, sorry, Back in the day, you went to Disney and you said you could never sue. We got this arbitrator that's going to give you $500.
Yeah, good luck and good day, sir. Good luck,
I like that. Super injuries. Yeah, you know, Hawk Law Group, super injury lawyers.
Yeah. I like that too.
So, you know, we're going to wait and see it to shake out, but I want the public also to look at why this is the headline. Because there is a lot more than ever manipulation of the public when it comes to politics, when it comes to commercial and stuff like that. And being aware of what's happening and the way things are being presented to you, right, allows you to assign whether or not that's actually something that's pretty significant. In this case, anytime that they take a little guy and then they show a big guy just picking on the hell out of him, right, your antenna should go up right away, because they're putting that story in there first and foremost because it's salacious. If you have a politician that did something, you know, strange, you know, with a woman 25 years ago, right, and let's just say they went to a drag show or dressed in drag or whatever, why are they doing that? Because they're touching on your nerves as far as your you know, this person is outside of the norm, and I don't want to be included with, you know, the people that are outside of the norm. And it's like, so they are actually touching on things that don't matter, and that should give you a clue as to whether or not this should really be a trusted news source and whether or not you should actually pay attention to them. Because unless they're giving you good, valid information to act on, you know, I don't think you should trust this thing. So people always talk about how we can't trust the news at all, and we need to reform the press and all that stuff. Actually, how about we just get a little bit better at sorting out what's BS and what's actual things that we need to actually worry about. So,
well, my final thoughts on it are, like you're talking about the general public and what to think about. I say don't give away your rights, people, and because you're never getting them back. Anything, med-mal is a perfect example. Medical malpractice.
Sure.
The society gave that away. It's a $250,000 cap, which was a lot of money back when it was done. Every day it gets less and less.
Right.
But that number's not going up.
No.
You're not. It's just not going to happen. When you give away a right, you're not getting it back. And everybody is outraged when it's to them, against them, or hurts them, or they're in the situation. But nobody really cares. They do care, but they don't. You know, it's like, oh, it was somebody else. But when you give away the right to a jury trial in anything, when it happens to you, you will regret it.
Absolutely.
So I said I was going to talk about the Karen Reid trial. I'll try and cover that just real quick. There was a hearing August 9th in which the defense actually sought to have a second hearing, an order, a request from the judge to issue an order to have a hearing including all of the jurors to determine whether or not Karen Reid they'd reached a unanimous verdict on 2 of the counts against Karen Reid. That was heard on August 9th, and the judge has yet to rule on it. We will give you an update on sort of how that shakes out and what kind of ruling that the judge gives.
And what it means.
And what it means next time.
In layman's terms.
Yeah, hopefully. So thank y'all very much for joining us. Oh, side note, I do have a question for you guys, you longtime followers. If you guys want to participate, y'all want to win a Hawk Law Group official law call mug, you can go to hawklawgroup.com to help find information about this. But I would like to know in the comments, the first person that answers gets the mug. What are the intangible damages for a wrongful death lawsuit?
In Georgia.
In Georgia. That's right. In Georgia. And again, that's hawklawgroup.com. Thank y'all so much for watching. We'll see you next time.